counsel to the final round of the Osgoode Cup. Take your time to set up and then let us know when you're ready to proceed.
May I proceed, Justices?
You may proceed.
Thank you. Good afternoon, Honorable Justice of the Court. My name is Jenny Trang, and I am accompanied by my co-counsel, Serena Aladina. We rise on behalf of the appellant, Mr. George Zacharias, in the case at bar. Would your Justices require a brief summary of the facts?
That is not required, counsel.
Thank you. The appellant requests that the Supreme Court of Osgoode Hall allow the... Closer? Is this better? Okay. Thank you. The appellant requests that the Supreme Court of Osgoode Hall allow the appeal, order the exclusion of the evidence, set aside Mr. Zacharias' conviction, and enter an acquittal. The appellant has 4 submissions to make before the court today. Our first submission is that Mr. Zacharias should be permitted to raise subsequent charter breaches despite not being brought forth before the trial judge. Our second submission is that unlawfully obtained evidence cannot establish reasonable and probable grounds. Our third submission is that consequential breaches can increase the seriousness of an infringement under the Section 24(2) analysis. And our fourth and final submission is that the evidence must be excluded. I'll be addressing the first 2 submissions today, and my co-counsel will address the last 2. To begin, the case of Gwendon has noted that the court does have the discretion to hear and decide on new issues that were not brought forth at the trial level.
Counsel, first thing is, if you can still move the mic a little bit closer to you, maybe assistance to us. Second of all, why should that discretion be applied in this case? In other words, what makes this case exceptional?
Justice, we would submit rather than taking the exceptional circumstance approach, we would note that in Gwendon it notes that 3 factors must be taken into account if the court will use its discretion to hear on these new issues. And these 3 factors would be fairness to all parties, the condition of the record, and the importance of the court hearing on these new issues. And I will address each of these in turn today.
Counsel, before you do that, what I'm interested in knowing is, I'm sure your friends will argue that there is significant prejudice to them having not led certain evidence at the trial level. Can you please address how that wouldn't be the case in your submission?
Justice, we are in agreement with the majority at the Supreme Court of Canada that addressing these new issues would not prejudice the Crown. For the reason being, we submit the Crown has had plenty of time and opportunity to respond to both the position of the majority of the Supreme Court of Canada and the dissent at the Court of Appeal. Thus, while these issues may be being brought forth by Mr. Zacharias for the first time, it would not be the first time that the Crown would be hearing these issues.
On what basis do you take that position, counsel, when notice of the charter issues was not provided at the trial level?
Justice, we do acknowledge that notice was not provided at the trial level, but we would still submit that using this court's discretion, once it's established that there's no prejudice to the Crown, as well as a sufficient evidentiary record, and the third prong importance of addressing this issue, we would urge this court to consider these issues today. Moreover, the Crown put forth at the Court of Appeal that they would have called in new evidence only if the strip search was raised at an issue at the voir dire, which it was not. Therefore, similarly as found by Justice Couillard at the Court of Appeal, we would submit that the Crown would not have adduced any additional evidence in relation to any other breaches that were brought forth.
So is it your position that this not being raised at the trial level, if it were to prejudice anybody, would only have prejudiced your client?
Would you be able to rephrase your question? My apologies, Justice.
The strip search wasn't brought up at the trial level, so is your position that had these issues been live at the trial level, the record might have been even more compelling for your client, and therefore these new issues arising late, if it prejudices anybody, it doesn't prejudice the Crown, it prejudices your client?
Justice, we would submit that it would not prejudice our client to bring forth these issues today. Given that at the trial level, we noted that the trial judge failed to consider the consequential Section 9 breaches, which is why which is why it was brought forth at the Court of Appeal, but because it was denied, we are bringing it forth again to the Supreme Court of Osgoode Hall today. We would further submit that allowing Mr. Zacharias, our friends may suggest that allowing Mr. Zacharias to raise these new issues will elicit additional evidence. However, the appellant has made clear that arguments for these new issues will only rely on existing evidence that the Crown does not contest.
Isn't there an unfairness between your first and third issue? On the one hand, you're saying there's no prejudice to Crown if evidence was not adduced. On the third issue, you want to still consider the seriousness of the consequential breaches.
In relation to the third issue, we would note that Justice Couillard at the Court of Appeal stated that an appeal court may have a duty to hear on new issues if not doing so would result in unfairness, particularly when the liberty of an individual is at stake, which we submit is the case of Mr. Zacharias today. And thus we submit.
Do we need a finding from the trial judge on the constitutionality of the charter breaches to be able to consider your submissions? Or can we independently at this stage rule on whether the later arrest was unconstitutional?
We would submit that because the trial judge did not consider the subsequent Section 9 breaches after the sniffer dog search, that this court today can still take that into consideration and decide on the breaches.
If the trial judge didn't rule, why would the better option be to send it back for a new trial?
Justice, we would submit that it would not be in the best position to send this back to the trial judge, given that even at the Supreme Court of Osgoode Hall, we will still be owing deference to the trial judge's findings of facts. Therefore, it is sufficient for this new court to address the issue still.
Counsel, I'm still stuck on why you will not concede that exceptional circumstances is what's required here, given that the majority of paragraph 23, citing Gwindon as it was referred to in JF, used that exact terminology.
Justice, the reason we're not conceding that it's an exceptional circumstance is because in Gwindon it noted that in order for an exceptional circumstance to be proven, they needed it to be an overwhelming urgency or of public importance. And given that at the lower court the appellant did not make submissions in relation to the overwhelming urgency aspect, we're focusing solely on the discretion of the court and again the three prongs of prejudice, evidentiary record, and the court's importance in addressing the issue. Now I will turn to our position that unlawfully obtained evidence cannot establish reasonable and probable grounds. Justices, we submit that in taking a principled approach to the Charter, it mandates that the police cannot rely on unlawfully obtained evidence to conduct a warrantless arrest.
Counsel, are you urging us to adopt the American fruit of the poison tree test?
Justice, no, we are not submitting that taking our approach would rise to the fruit of the poison tree doctrine, given that what we are submitting is that the unlawful sniff search be removed or excised from the factual matrix and then the story test be conducted. So the story test has two components. That is when an unlawful arrest, a warrantless arrest is made, the police officer must have subjectively believed the person has committed the offense and that belief is objectively reasonable. From there, even when the evidence, in this case the sniffer dog search, is removed, the story test will still be conducted to see if the officer had reasonable and probable grounds present to conduct those subsequent arrests and searches.
Counsel, what room is your analysis leaving for the fact that this was a more dynamic situation than a warrant search would, I suppose, warrant?
Justice, we will concede that arrests without warrants are often conducted by police officers in rapidly changing or dynamic situations, but we submit that nonetheless, this should not stop a police officer from ensuring they're acting within the Charter. They must respond to urgent demands while still being mindful of the authority that is conferred by the law.
But it seems like you're asking for a standard of perfection, because here we've got a minuscule breach, and you're saying that that's going to invalidate entirely the evidence that was used for a lawful arrest. So in that situation, the only thing you could have done better is to be perfect. And so I'm worried about the standard that this is going to set for future police interactions.
Justice, we are not submitting that the police officers have to be perfect in their actions, but rather just ensure they are complying with the Charter. As highlighted in Story, in cases of arrest without a warrant, it is even more important for police to demonstrate that they have reasonable and probable grounds upon which they base this arrest. The police have been and continue to be required to consider whether or not they are acting within constitutional limits. Siding with our friends would allow for the state to benefit from the illegal acts of police officers, and not excising the unlawful search allows the state to minimize the impact of previous unconstitutional actions.
Counsel, the challenge that I have is that in a case where there's a minuscule deficiency, we're unable to meet the story test in that case. In what case would we be able to meet the story test?
Justice, while we do acknowledge that in this case, Constable McPhail's infringement on Mr. Zacharias' rights were minuscule, we would turn to the fact that his experience in the field over 14 years and conducting 12,000 to 15,000 stops actually lends to the fact that he should have known to act within the charter when arresting and searching Mr. Zacharias.
Counsel,
Go ahead.
Counsel, what would you have had him do in this case? What would have been the appropriate course of conduct in your view?
Justice, while we're not here to submit exactly what Constable McPhail could have precisely done, in this case, we would submit that had, for example, starting with the reasonable suspicion to conduct the sniff search in the first place, had he found, when contacting the real-time information center, had he confirmed that it was reliable, when in the case the real-time information center informed him that it was unconfirmed, the offenses that they had brought up. So that is one example. However, in turning to the sniff search itself, we maintain that that could not have been used to form his reasonable and probable grounds once it was deemed by the trial judge that it was unlawfully obtained.
Counsel, you brought up the experience of this particular officer, but doesn't that experience lead us to, I guess, form the conclusion that the standard that you're asking for is really just too high for a police officer in general? If this particular police officer, with all his breadth and depth of experience, just missed the mark, isn't what you're asking for really perfection?
Justice, I see my time is elapsing. If I may have a brief indulgence to answer your question and conclude. Thank you. Justice, we would submit that this is not too high of a standard to hold police officers to, given that Canadians expect that the police will know the law and comply with it. As found in Tim particularly, allowing the police to arrest someone based on what they believe the law is, rather than what it actually is, would dramatically expand police powers at the expense of civil liberties. To briefly conclude, Honorable Justice of the Court, it is clear that there is a sufficient evidentiary record and no prejudice to the Crown to decide on the new issues being brought forth by Mr. Zacharias. To allow for unlawful evidence to be used to justify reasonable and probable grounds would go against the principles of story as well as our court's jurisprudence. Barring any further questions, my co-counsel will now address our last two submissions. Thank you.
Before I proceed, can I just check that my sound is okay? Is that okay? Perfect. May I proceed, Justices? Good afternoon, Honorable Justices of the Supreme Court of Osgoode Hall. My name is Serena Alidina, and I rise to conclude submissions on behalf of the appellant, Mr. George Zacharias, in the case at bar. The appellant's third submission today is that consequential breaches can increase the seriousness of an infringement under Section 24(2). Our final submission is that the evidence must be excluded. To begin, Justices, today we respectfully reject the view put forth by Justices Rowe and Abonsawin that consequential breaches can be seen as less important simply because they're expected to occur. In fact, as a matter of settled law, Section 24.2 and the grant analysis mandate assessing the cumulative and potentially compounding seriousness of all of the conduct related to each of the violations at issue.
Counsel, can I just clarify, is it your position that consequential breaches should factor in at first, second, or both factors of the grant test?
Our position, Justice, is that the consequential breaches should be factored into the first and second set of grant factors.
Doesn't that feel like you're putting a pretty heavy finger on the grant scale by double counting the same breach?
Justice, respectfully, the appellant's position is that we're not double counting the breaches. What we are instead doing is recognizing the gravity of the offenses that Constable McPhail engaged in.
Let me ask you this. Let's say for a moment that that Officer McPhail had reasonable suspicion. Is there any issue with any of the police action thereafter?
Justice, our position is that had Constable McPhail established reasonable suspicion, perhaps there would not be issues with any of the subsequent action.
So explain to me how the subsequent breaches increase the seriousness of the state action.
The reason why the subsequent breaches increased the severity is because they became increasingly invasive with each step, Justices.
But that sounds like it's a question about the impact on these two. I think we're all confused on why it's an increase of police misconduct when there was no further actions that might be considered to be charter violations.
Certainly, Justice. If we are to take a look directly and only at the first grant factor, adopting the broad social perspective that grant mandates, these increasingly invasive steps represent progressively more serious ways in which the state conduct undermined the rule of law. And
Go ahead.
Perhaps you can explain to me, how were the subsequent steps invasive?
Certainly, Justice. It must be stressed that objectively the police had no legal authority to interfere with privacy and liberty. And so by engaging in these deprivations of those rights and continually engaging in those rights, it became more and more invasive.
Is it the nature of the breach that we're concerned about, whether it's more invasive, or the fact that the breaches occurred?
I'm so sorry, Justice, I couldn't.
Is it the nature of the breaches that we're concerned about, or the fact that they actually occurred?
Justice, the appellant would suggest that both are relevant. That the nature of the breaches was based on unlawful action, and then the fact that they occurred led to increasingly invasive next steps.
Isn't there a third part of this consideration that you're missing, which is the intentions of the police and whether they were acting in good faith? I'm pretty sure there was a finding of good faith, right? So shouldn't that offset some of the severity?
Justice, our position is that even inadvertent breaches, like Constable McPhail's, which were found to be in good faith and good conscience, may still weigh in favor of exclusion, and that is because a breach based on an honest and unintentional mistake is nonetheless a state action taken in the absence of legal authority.
That sort of sounds like we're doing away with the first line of inquiry as a whole.
If you're just focusing on the seriousness of the impact, you're not really thinking about whether the police actually engaged in misconduct.
And Justices, that is why we have the third line of the grant analysis, and so that serves as sort of a balancing mechanism. And the appellant would concede that there is a strong social interest that favors the adjudication of these charges on the merits. And
You use the word may, but where in the particular circumstance of this case, to what extent are the breaches mitigated by good faith?
Justices, our position is that the breaches cannot be mitigated in this case at bar.
The officer's honest belief does not enter your analysis?
It is entered in our analysis, but it has not reached a threshold where it is enough to counter the seriousness and the impact of the first two grant factors.
So if I'm understanding your analysis correctly, counsel, if a police officer stops somebody simply because they're wearing a green hat, and everyone who's wearing a green hat in that police officer's view is a criminal, is that the same on the first stage of the grant analysis as what happened here?
If you're not considering it,
I'm so sorry.
because it sounds like you're not considering the officer's intentions.
Justices, the appellant will gladly recognize that not all conduct that violates the charter necessarily deviates from the rule of law to the same extent.
But can you focus in on the facts of this case? So how does good faith play a role in this particular case in terms of seriousness?
In the case at bar, good faith was acknowledged, and it was considered as part of the third grant factor. In considering society's interest in the adjudication of the case on its merits, we must factor. Okay.
So how does good faith impact seriousness in this particular case?
With regards to good faith impacting the seriousness, our position is that there is no deference owed to the trial judge's reasons for judgment, and that includes her reasons regarding good faith.
You seem to be dancing around the issues. What is your analysis as to good faith in the particular circumstances of this case?
Despite Officer McPhail or Constable McPhail exercising good faith, the fact is, Justices, that these increasingly invasive steps mandate that on the spectrum of seriousness that the Supreme Court of Canada identified in Grant, the conduct at issue in this case pulls strongly towards exclusion.
So good faith then has little weight in the particular circumstance of this case?
In this case, yes. But Grant emphasizes a case-by-case analysis, and so this wouldn't be setting a dangerous precedent by any means.
What about the relatively unintrusive nature of the search? How does that, I agree that good faith, I'm not sure I understand your answer on that, but what about the fact that it was a sniff rather than a more just or intrusive type of search? How does that play into the analysis?
So in analyzing the sniffer dog search in comparison to a perhaps more egregious search, like a strip search, our position is that despite the sniffer dog search being not as egregious, it did still have an impact on the rights of Mr. Zacharias, and it poses a risk to public confidence as well in the system. In fact, as the lower court acknowledged in the reference case of the BC Motor Vehicle Act, the legal rights protected by sections 7 through 14 of the Charter are essential elements of a system to the administration of justice, which is founded upon the belief in dignity and worth of the human person and the rule of law.
Do you concede that both good faith and the relative unintrusiveness of the search lessen the impact or lessen the seriousness under that provision?
Respectfully, Justice, we do not concede to that position.
Not contrary to Shahill and the fact that this court has found that sniffer dog searches are minimally intrusive?
I see my time is elapsing. May I have an indulgence to answer your question? Thank you. Justice, our position is that subsequent conduct consequential to an initial breach is part of all of the circumstances to which Section 24 requires courts to have regard, and this court must have regard to the sniffer dog search and the additional breaches. To briefly conclude, Justices, the appellant's position is quite clear. All that we ask of you is to guard the civil liberties of Canadians fiercely, because they are the beacon that lights the path towards a just and equitable society. And so on the basis of law, reason, and policy considerations, we urge this court to allow the appeal, order the exclusion of the evidence, set aside Mr. Zacharias' conviction, and enter an acquittal. Barring any further questions, the appellants rest.
Testing. It doesn't go down. Hello? Yes. Okay, I can do that. Justices, may I proceed?
You may proceed.
Good afternoon, honorable justices of the court. My name is Rehana Lelani. My colleague is Jonathan Kagal, and we rise today on behalf of the respondent, His Majesty the King. Our submissions rest upon preserving the concept of reasonableness that guide the story and grant tests. And with this, we have 3 submissions for you today. First, unlawfully obtained evidence can provide grounds for a warrantless arrest. Second, cascading actions flowing from a charter breach will play a limited role in the grant analysis. And third, a balancing of the 3 lines of grant inquiry will favor the admission of the evidence.
So, counsel, are you conceding the issue that this court can consider issues that were not raised before the trial?
We are conceding on this issue.
Thank you.
And in your submissions, counsel, can you ensure that you address on the impact of the position that you provide in the court on the rule of law?
Yes, Justice. Could I ask you to just simply repeat that so I can note it down?
The impact of your submissions on the rule of law. And if you need further clarification, I will be happy to provide it by formal questions as you proceed.
Thank you, Justice. To begin, as noted again, we concur with our friend's submissions that the issues raised on the Court of Appeal are to be considered today. So we move to our first area of contention, which is that unlawfully obtained evidence can provide reasonable and probable grounds for arrest.
Can I just clarify your position on concession? Are you conceding that the subsequent police action were breaches?
We are not conceding that they are breaches. We simply agree with our friends that these are issues that should be raised today, and we should be talking about them in this court today. We do not submit that they are consequential breaches, though. This case, at its core, is about the court's ability to balance reasonable police conduct with public interest. The application of the story and grant tests must reflect the realities of policing, while still being able to uphold public confidence in the administration of justice. We submit it is unreasonable to assume that an officer will not act on incriminating evidence, even when...
Does that mean that are you removing any barrier to using unlawfully obtained evidence as grounds for reasonable medical defense?
The respondent is not submitting that. We are simply stating that if an officer has a subjective belief that is found at the trial level, which was found at the trial level, that he had a subjective belief that he had those grounds, then unlawfully obtained evidence may be relied upon in this context.
Are you doing away with the objective element of the test then?
We are not doing away with the objective element of the test. To clarify, the story test has the subjective component and then the objective component, which states that the subjective belief must be objectively reasonable in the eyes of a reasonable person standing in the shoes of the police officer. And it is our submission that unlawfully obtained evidence can still be objectively reasonable. That a person with Constable McPhail's experiences and the number of traffic stops he had would still make the same decision that Constable McPhail had made when standing in his shoes.
What of the obtained in a manner requirement of the fact that all this evidence flows clearly from an unlawful detention?
Sorry, could you repeat the question?
What about the obtained in a manner requirement of the fact that this evidence flows from an unlawful detention?
It does flow from an unlawful detention. We do know that these breaches that these actions were a result of the initial breach. However, we do not submit that they are additional breaches today.
How do you reconcile that with the obtained in a manner requirement?
Sorry, Justice, could you expand?
With the obtained in a manner requirement?
We submit that although that the evidence was obtained from an unlawful arrest, that it still should be considered today. It still is objectively reasonable when we consider it through the story test.
But and to go back to my fellow justice's point earlier, doesn't that have really negative implications for the rule of law if we're allowing police officers to consider unlawfully obtained evidence to ground their future actions?
Yes, so it is our submission that the rule of law does hold police accountable for their actions, and we submit that the police should be held accountable for the initial charter infringing conduct. However, the steps following this were natural investigative steps that would have been taken by any police officer who had found 100 pounds of marijuana.
So, counsel, whether it's natural or not, perhaps is a secondary question to what the court in Grant, 1993 Grant, stated at page 251, which is that the state is prevented from benefiting from the illegal acts of police officers. And so isn't that what we are doing here today, in light of your submissions, is giving effect to the illegal acts of police officers?
We would submit that the Crown knows that the police should absolutely be held accountable for their actions, and they are being held accountable for the actions of the initial charter breach. However, it's difficult for the police, in this case, or Constable McPhail, to benefit from something that he didn't even know was wrong. And imposing the standard upon police will set a standard of perfection that is unattainable in these dynamic situations that happen for warrantless arrests.
How are the police being held accountable here?
The police is being held accountable for his initial charter breach, the Section 8 and Section 9 charter breaches.
But not if we ultimately allow the evidence in, right?
We would submit that, as my co-counsel will further expand upon, admission of the evidence the Grant test is not focused on punishing the police for their actions. It's focused on society's interest in the case, of upholding confidence in our justice system. And it is our submission that Section 24.2 is not about the police or punishing the police. It's about...
Are you retracting your earlier submission that the police then are being held accountable? Are you retracting that?
No. It's our submission that the police should be held accountable for their initial charter breaches.
Okay, but to my friend, are you asking us also to not excise this evidence from the factual matrix?
It is our submission that the evidence should not be excised from the factual matrix, and then
So we're not excising, and we're not excluding?
Yes.
Okay, and so then how are we holding the police to account? I understand your submission regarding punishment, and I agree, but there has to be some form of accountability that police in general know that we are going to review these kinds of actions.
It is our submission that the story test does hold police accountable to a reasonable standard. That if they do not have the subjective belief that they are even proceeding lawfully, then they will immediately not meet the story standard.
It's your position that no matter how unreasonable their subjective belief is, that being the officer, that we consider and accept that belief for reasonable and probable grounds, no matter how outlandish it may be?
No, Justice. We do recognize that the story test does have a subjective and an objective component, and that a reasonable person standing in the shoes of the police officer would have made the same decisions that the police officer did in that instance. And it is our submission that a person standing in the shoes of Constable McPhail today would make the same decisions he made.
We should hope not. We should hope not, right? Because the trial judge found that there was a breach.
Right. I'm speaking about the warrantless arrest context. It's not our submission that Constable McPhail didn't originally breach Section 8 and Section 9. We do concede that he missed the reasonable suspicion standard by a minuscule amount. We've moved on to the warrantless arrest context, where we do believe he has reasonable and probable grounds.
Right. Based on the sniffer dog search that was unlawfully, the evidence for which was unlawfully obtained.
Yes, we do not believe.
Why are we considering that evidence?
We are considering that evidence because we do believe that police can rely on this unlawfully obtained evidence to meet the reasonable and probable ground standard, and that it should not be excised before proceeding to the story test.
Counsel, when in a search warrant context, I think it's well settled law that an unlawful search cannot furnish the requisite grounds for a search warrant. Why is this different?
I would quote Beaver to you at paragraph 72 that the dynamics at play in arrest situations are very different from on those which operate on an application for a search warrant. The officer's decision to arrest must be made in very quickly and volatile situations, and requiring an officer to do a retroactive judicial assessment in the heat of the moment for a warrantless arrest would fundamentally undermine the public's confidence in our justice system.
More important to have judicial safeguards in a warrantless context?
It is important to have judicial safeguards in a warrantless context, but it must also be recognized what police can do reasonably when they are in these situations.
I'm worried now, if I agree with you about this flexibility, I'm worried about the possibility that we're going to allow more and more police misbehavior to get in at this warrant, using unlawful evidence for reasonable and probable grounds. Like, is there a limit to what misconduct they can engage in while they can still consider that part of the reasonable and probable grounds?
It's our submission that the story test still stands, that they must have that
Under your submission, the objective component of the story test can consider all evidence regardless whether or not it was unlawfully obtained. Is that correct?
Yes, in the warrantless arrest context.
Right. So if a police officer then walks into someone's home without a warrant and finds drugs, can that also ground reasonable and probable grounds for an arrest?
It would be our submission that there would have to be a judicial reflection on that, and an objective person standing in the shoes of that police officer would have made those same decisions. He must subjectively believe it, which we don't know if the officer in your hypothetical situation has, and we also don't know if that would be objectively reasonable from the court's point of view. I see my time has elapsed. To conclude, our first submission, automatic excision should not be applied in situations of warrantless arrests. And barring any further questions, my co-counsel will proceed. Thank you.
Justices, can you hear me? Yes. Okay. Justices, may I proceed? Good afternoon. My name is Jonathan Kagal. I will address our final two submissions on behalf of the respondent. I will first address how, under the first line of grant inquiry, cascading actions that flow from unlawful conduct are unlikely to materially change the analysis. I will then proceed to demonstrate how a weighing of the grant factors in the instant case favors the admission of evidence. To begin, the first line of grant inquiry asks the court to determine how the reasonable person among the public would perceive charter infringing conduct. This differs from the second line, which asks how charter infringing conduct actually undermines the impact of the accused. It is under the first line that when discussing the cascading actions that flowed from Constable McPhail's unlawful investigative detention and sniffer search of Mr. Zacharias' vehicle, these cascading actions are unlikely to affect how the public perceives the entire interaction.
Well, let me ask you this. We have this entire course of conduct from the time of the unlawful detention right through to his release from custody 6-7 hours later, right? Are you submitting that that we should not take that into account at the first stage of grant, where, let's say, they release him on scene, right? So we've got this whole, 6 hours later that could have been avoided, perhaps, right? I'm trying to understand, do we look at this as one transaction, or are we just focusing on the initial potential?
Justice, it's our submission that we should focus the first line of inquiry on the initial independent state misconduct, because as Chiho reminds in paragraph 55, officers are expected to take investigatory steps after uncovering incriminating evidence. And that is what Constable McPhail did in the case at bar.
Well, when we're looking at those different steps, though, Grant is quite clear at paragraph 86 that the court is not to conduct a mathematical exercise in doing so. And so in that case, and the dissent refers to this in paragraph 134, why should we not be looking at these incidents cumulatively in assessing its seriousness?
Well, Justice, in not considering the cumulative impact, we do not submit we are assigning any sort of mathematical precision to the Grant inquiry. We are simply upholding the scope to which the first line is meant to be applied, which is how does the public perceive what the police did? And there is no instance, we submit, where a reasonable person among the public does not reasonably expect that the police will further act upon incriminating evidence.
But they would reasonably expect them not to act upon incriminating evidence that they only found as a result of unlawful means.
Well, Justice, in the instant case, it was noted that Constable McPhail did not know that he had missed the lawful justification for the sniffer search by a minuscule degree. And as we will demonstrate when we weigh the factors under the first line, that does lower the poll for exclusion. However, the animating principle behind this first line is that the public does expect police officers to act upon information that indicates there could be a crime that they should act upon. And in the instant case, when Constable McPhail was given the indication that from the sniffer dog that there was a controlled substance in Mr.
Counsel, I'm going to stop you there because you're jumping to the sniffer dog. Is this analysis, when we're looking at the seriousness, instead the fact that if you have a broken taillight, you may get strip searched?
No, Justice, that is not our submission. A broken taillight only talks about the subjective component of the story test. The story test is made with a subjective and objective component to ensure that nobody can be arbitrarily detained or have any arbitrary actions result in cascading charter infringements. It is our submission, as my colleague outlined, that the story test was satisfied not just because there was a subjective belief because there were broken taillights, but because Constable McPhail had the indication that there was a controlled substance in Mr. Zacharias.
I'm going to rephrase my question because it isn't a story question. Is not being strip searched serious?
Yes,
Justice. Grant test.
Yes, it is, and that will be factored in under the second line, which asks not how society views police actions, but how police actions actually undermine the protected interests of the right infringed.
Can you respond to what I take as your friend's argument that the good faith of Constable McPhail doesn't actually factor into the first prong of the Grant analysis?
Justice, we do not concur with that sentiment, and it was noted in the Crown and Tim that good faith on the part of an officer does reduce the need for the courts to disassociate itself with unlawful conduct because the public has a greater interest in having the court disassociate itself from what it perceives to be willful misconduct. Therefore, when applying these principles to the instant case in the first line of Grant inquiry, our friends have noted that not all deviations from the rule of law are serious to the same extent, and we concur. When focusing on the initial independent breaches, this was a deviation from the rule of law, but the trial judge noted it was off to a minuscule degree.
Why can't we give full effect to the breaches and let good faith do its work when assessing the seriousness? And that mitigates the seriousness.
Justice, we submit we are applying full weight to the breaches in this case.
For seriousness?
Yes, Justice.
So do you agree that if we were to rule in favor of the appellants, the real issues that would be determinative for those appellants are the second and third prongs of the Grant test and not the first?
No, Justice. We do deviate from our friend's conclusion on the first line as well. Since we are focusing on the initial independent state misconduct, we submit the first line can at most only moderately favor the exclusion of evidence.
Right, but what I'm asking is, suppose I agree with you, and my fellow justices agree with you on the first line. Would you agree that the appellant's position at its highest really comes down to the second and third grant lines of inquiry? That's what this case is really about for the appellants.
If you accept our submission on the first line, then yes, it would come down to the second and third.
And do you agree that the second and third lines of inquiry are the appellant's case at its highest? That those are the most compelling positions for the appellant, 2 and 3?
Well, Justice, there are two things to say to this. It's possible they're more compelling. However, it's our submissions that our friend's submissions on both the first and second line should not be taken by this court. And second, to reiterate, there's no mathematical precision in this analysis, and no one or two lines are ever to be weighed more than the others. Now,
let's get to the second stage then, because I'm interested in your position on that. My first question indicated, right? It seems to me that there is an argument to be made that this was one transaction from the start of the traffic stop to its ultimate release at the end of the day, right? And so we have a charter breach at the outset, and then we have all these actions that flow from it, and all these interferences with this person's liberty and their charter protected interests. Pat-down search, detention in the back of the vehicle, arrest and taking back to the station, strip search, being held for 6 hours. Get that time back. That is time taken from Mr. Zacharias and dignity. And that's time and dignity taken from Mr. Zacharias that he can never get back. So how do you differentiate from the appellants that this is not at the high end of interference with charter protected interests?
Justice, we differ from our friend's submissions in the second line, not in the consideration of cascading breaches, we consider them, and not in the fact that it weighs toward exclusion, it does. But it is our submission that the court's jurisprudence on the second line of grant inquiry, when there are cases that do strongly weigh toward exclusion, those involved greater impacts on on the interests protected by the right infringed.
Do you have examples?
Yes, Justice. In the Crown and Patterson, that was the case of an unlawful search. The second line weighed strongly toward exclusion because that was a search of a private residence. In the Crown of AM, the same thing happened in a school. Both attract a higher expectation of privacy than
the search of his body.
Justice, if
he was strip searched, right?
No, the Court of Appeal found it did not constitute a strip search by the technical sense.
Okay, so he wasn't stripped naked.
Yes.
Had his clothing removed and he was searched.
Yes, Justice.
Okay, so a search of his body.
Yes.
Okay. How is that not at the most significant range of charter protected interests? How is a house greater than the body?
Because, Justice, in similar cases, when a cascade of interactions started from lawful conduct, that mitigated the arbitrariness of state conduct to a certain degree. In the Crown and Tim, there was an unlawful roadside detention. However, it began through a lawful roadside stop, and that led to a moderate pull for exclusion because the Crown and Tim said the arbitrariness of the conduct was mitigated to a certain extent. We submit the facts are analogous in this case, which is why the second line only moderately favors exclusion. Moving to the third line of the grant inquiry.
Isn't really what this case about is we have inadvertent good faith police conduct that has a very substantial impact on Mr. Zacharias' interests, and the police are investigating a relatively serious crime. So isn't really where you are planting your flag on 1 and 3, and can't you just concede that the impact on Mr. Zacharias was serious, but 1 and 3 outweigh 2?
No, Justice, we would not concede that because the first line still weighs toward exclusion. As stated in the Crown and Lee, the first two lines will always at least weigh toward exclusion, which is why the third line is so important. Now, to our submissions on the third line, both sides of the Supreme Court agreed it strongly weighs toward admission. In the absence of significant divergence from that matter from our friends' submissions, we will proceed straight to the final balancing, where we submit that this court should remember the purpose of the grant inquiry is to refine the exclusionary Stillman standard. that held that conscriptive evidence, once that threshold is met, can discard societal interests in the prosecution in excluding evidence. Grant refined this framework by giving equal weight to the cumulative effect of the first two lines and the cumulative pull, and the pull from the third. It is under this approach that we submit the third line, which is a strong pull, outweighs the moderate pull of the first two. Barring it.
Exactly is the contributions to your strong pull under the third line, just so I can clarify?
Sorry, Jessica, can you repeat the question?
Under the third line, you're saying it's a strong pull. What factors go into that in your view?
First, I see my time has approached. If I can have a brief indulgence to answer the question. Justice, we rely only on the reliability and relevance of the impugned evidence.
Not the seriousness?
No, Justice, because seriousness cuts both ways. Our friend's request for an acquittal has shown just how relevant the evidence is, and sniffer searches, even when unlawful, such as was the case in the Crown and King Brown, were found to be highly reliable.
Is credibility and relevance enough to create a strong pull under the third line? Don't we need some degree of seriousness?
Well, Justice, it is a well-established principle that seriousness always cuts both ways. So any case that has warranted exclusion has relied primarily on relevance and reliability. Barring any further questions, this concludes the respondent's submissions. Thank you.
All right. First of all, congratulations to each and every one of you who participated over these last 2 days. What an experience. A round of applause for all of you. Great job, everyone. And then a round of applause for our organizers. They did an amazing job. And finally, a round of applause for our finalists. Look, we're all winners here today. We're all here for the experience. We all take away these memories. You will find that this is a foundation for your future. It's not just the mooting and what you've learned about the law, but rather the most important thing is the relationships you're going to build. This is your network. These are your colleagues. These will be your friends. Don't leave here without making connections, not just with your fellow students, but with the judges, with counsel. You'll find that in your career, it's not always what you know, it's who you know. And the most rewarding aspects of your career will be the relationships that you forge. So congratulations just on being here and being you. Now, in terms of the finalists, This was an incredibly difficult decision, and it became more and more difficult as we went along. The theme that the judges have had in our discussions in our chambers has been how high the level of advocacy has been over these last 2 days. And what we've talked about is that, and we've witnessed law students doing moots as well, to see undergrads performing at this level is absolutely incredible. And what we've talked about is that we've witnessed law students who've not done as well as you. So the future is very bright. All of you can do whatever you want in your lives. Set a goal, and I can guarantee you will achieve it with hard work and with the right preparation. We have no doubt. We were amazed at each and every level of this moot. So thank you very much for letting us witness this. Now, I'm not going to keep everyone in suspense any longer. We've been sweating bullets for 2 days here. I do want to announce the winners after our deliberations, and they are Jonathan Kagal.
Okay, so now we'll hand out the rest of the awards, and once you receive your award, I think we're going to ask you to just stand behind us here so we can take a picture of everybody all together. So we'll start with the top 16, and it's in no particular order, of course. So part of the top 16, from Wilfrid Laurier University, Team 78, Tamara Dujanik and Jack Newby. Medals. From York University, Team 48, Sarah Moniz and Gunit Kaur. They're not here right now, but from Concordia University, Team 68, Chiara Nunez Mancini and Zain Sakal. From the University of Toronto, Team 30, Atruba Shahid and Neha Gupta. From the University of Western Ontario, Team 99, Sean Meharabnia and Nolan Calderwood. From McMaster University, Team number 12, Miriam Sheikh and Sabrine Said. From the University of Guelph-Humber, Team 39, Navita Sear and Ruth Odit. And rounding up the top 16, we have from McMaster University, Team number 17, Ori Epstein and Arjun Thayaparan. Now moving to the quarterfinalists, we have From Wilfrid Laurier University, Team 91, Madeline DeRay and Aliyah Saeed. From the University of Toronto, we have team number 25, Ashvini Jiridan and Inalua Adidas. From the University of Guelph Humber, we have team number 40, Julia Doze and Kate Hilton. They're not here. And then rounding out the quarterfinalists from McMaster University, team number 14, Helen Wu and Michaela Miss. Now moving to our semifinalists from York University, team 47, Hasti Jamalamidi and Barbara Kroll. And finally, from the University of Toronto, team number 21, Ana Sofia Flores and Sylvana. Yeah. And then maybe we'll have the finalists and the champions come back up and we can take a picture. Sorry? Oh, like everybody come on? Oh, sorry. We had the finalists from the University of Guelph Humber, Serena Aladina and Jenny Trang. Yes, and the winners of the 2024 Osgoode Cup from the Wilfrid Laurier University, team number 59, Jonathan Kagal and Rehana. Okay, and now we'll just go over the top 10 oralists, or the top 9, and then the top oralists at the end. So one of the first ones, she again is not here, but from Concordia University, from Team 68, Chiara Nunez Mancini. Our next top ad oralist is from Wilfrid Laurier University, team number 59, Rehana Lelani. From the University of Toronto, team number 30, Atruba Shahid. From York University, team number 48, Guneet Kaur. From Wilfrid Laurier University, team 78, Tamara Jujin. From York University, team number 47, Hasti Jamalamidi. From Wilfrid Laurier University, team number 59, Jonathan Kagal. From the University of Toronto, team number 25, Iniolua Adidapo. From Wilfrid Laurier University, from Team 78, Jack Newby. And our top advocate at the 20th Annual Osgoode Cup is from the University of Toronto, Team 30, Neha Gupta. Thank you everyone for an amazing 20th anniversary. We couldn't have asked for better speakers to join us. We couldn't have asked for a better team to help us plan it. We couldn't have asked for better mooters to come and show everything that they've prepared for us. So thank you all very much, and we'll see you next year at the 21st Annual Osgoode Cup.
And just, I promise the absolute last thing. Kiana's up here. I mean, you know, she's been absolutely amazing. Owen's been absolutely amazing. I just think, you know, there's a whole support group of people. They are law students and they're helping out at the same time. Law school is a stressful time. So I just ask everyone to give a huge round of applause, especially for Kiana and Owen, and all the work they've done. Because they've been amazing. And Jen, I took a step back when I was articling. Jen has been doing a ton of work, so I just ask everyone as well for a round of applause for her. And just this wouldn't we wouldn't be here without all the volunteers, all the other students, the operations committee. It's too many people to name, but all the lawyers and other people volunteering to come out, take their whole weekend. So I just ask everyone just a giant round of applause for all those groups. And thank you to everyone for making this a great Osgoode Cup. I hope to see people next year again, and I hope that those of you that move on, potentially to law school, that you consider helping out as well. So thanks so much, and see people next year. Officially closed. Feel free to take pictures.